Yeah, so yeah.
You're very much welcome, everyone. This is episode 3. We hope other people will join in time. Others are watching via YouTube. Thank you very much for joining us. You're very much welcome. Can I be heard? Am I audible? Somebody say something, please.
Yes, you're audible.
Yes, everyone. You're most welcome once again for our third episode of the Eminent Speaker Series. My name is Godfrey, Speaker, UCU Law Society. Well, I want to take this opportunity once again to welcome you all being part of us. It means a lot. As you are all aware, we have our people that are supporting us financially so that we are in position to have such an informative event. I'm so excited today about our guest speaker today, as the moderator will introduce her. But I want to take this opportunity to thank the UCU Law Society of both Mukono campus and Kampala campus, the president, Madam Elizabeth Kembabas, and Mr. Dominic. Thank you so much. I also want to thank our sponsors, Stadio Advocates, Council Bernard Oundo, President, East African Law Society. We are much obliged for your help and support. It's the reason why we are able to have such an insightful event. Well, I have nothing much to say, maybe to request each and every one of you that have attended the event, that are part of us, that after the event, you can give us feedback and we see how to improve, how we can make our Eminent Speaker Series more educative and stay trending. You can share ideas, anything that you want to share with us so that we can improve. Well, allow me to take this opportunity to invite our moderator for the event today, Iman. Madam Iman is the speaker, UCU Law Society, Mukono campus. Kampala campus, I beg your pardon. You welcome Iman, who will come in and introduce our eminent speaker today. Thank you so much.
Thank you so much, Luther. I'm on. Good afternoon to everyone. Can you hear me clearly?
Hello? Iman,
hello, can everyone hear me?
Yes, we can. Yes, we can.
Okay, thank you. My name is Asmahani Foum Iman, the speaker, UCU Law Society, Kampala campus, and I'm going to be the moderator for this session. I would like to welcome everyone that has joined us today, those that are new to the series, and those that have been coming for the previous series. We really appreciate the attendance. We have people from different universities, not only UCU, and really appreciate the effort. So the UCU Law Society series, which we call the Eminent Speaker Series, this is the third episode to those that have just joined us. We had 2 episodes before, and our first episode, the guest speaker was Dr. Daniel Ruhweza, who was talking to us about what we don't teach at law school. The second episode, our guest speaker was OHT David F. Kempanga, who talked to us about preparing for a career in legal practice. And today we have a guest speaker is Miss Stella Alibateese. So I would like to once again welcome everyone on the platform, and I would like to especially welcome Madam Stella for sparing time to talk to us. I'm going to briefly talk to you about Miss Stella before I invite her to impact us with knowledge. Miss Stella is currently the director at National Information Technology Authority, Uganda, NITA, but she's an information technology legal expert. She's an agribusiness enthusiast, and she is a practicing advocate. Miss Stella did an LLM at University of London and her LLB at Makerere University. She also has a postgraduate diploma at Uganda Management Institute, and she's certified with Information Privacy Manager. She's a certified Information Privacy Manager, sorry. She also served as a Deputy Corporation Secretary with NSSF, and she's a member of very many committees, and she has ever worked with the Hunter and Greg Advocates, which is one of the oldest law firms in Uganda, and she's also a Rotarian. So friends, when you go back and do some research on Miss Stella, you will really be impressed and know what an honor it is to have her talk to us and impact and share some of the knowledge that she has acquired. Miss Stella is part of very, very many committees, and she has really done a lot of work. She's very passionate about helping students and women. So I beg that we pay attention to what she's going to say. Those of you that are so interested in IT, cyber law, anything, technology, that is her expertise. So I pray that we all pay attention and gain from what she's going to talk to us about. Let us nourish our brains and take this opportunity as great as it is. So at this point, allow me to welcome Miss Stella to talk to us. Miss Stella, please, you're most welcome for the third episode, Eminent Speaker Series.
Thank you very much, Iman. I first of all want to thank the UCU Law Society for inviting me, especially after hearing those eminent speakers who spoke before me. I want to thank President Elizabeth, who reached out to me, and I'm happy to be here. I'm happy to interact with you today as you move on your journey to become excellent lawyers in this country and beyond it. I'm also happy that technology has also enabled us to be here today, and that it is the topic we are discussing today. When we were in law school about 25 years ago, please don't laugh, we used to, what I remember most vividly about our Makerere Law Society was our annual dinner, where we would interact with the lawyers and other professionals in the field. But it's good that beyond that dinner, which I'm sure you have also started these Eminent Speaker Series, because it is important to tap from within the sector and to be able to learn from it and also share experiences. So I'm very happy to be here. I had prepared a presentation because some of the topics I'm going to talk about are quite wide, which presentation, if you please, I'll share with the members after. If I could be enabled to share. Iman? Okay. As we handle the sharing of the presentation, I can go ahead and speak. Now, when we look at the topic I was given to talk about today is the law and business of emerging technologies and lessons and experiences for young lawyers. So in my discussion today, I'll do an introduction of emerging technologies so that we all understand what we are talking about. I'll talk about the legal and regulatory environment in which these emerging technologies operate. I'll provide an overview of the cyber laws, because those are the laws that we have currently that regulate the IT sector in Uganda. I'll talk about some of those legal issues as lawyers that you'll face when you're dealing with technology. And then I'll talk about some of the lessons that I would like to share with the young lawyers on this call. Now, when you define emerging technologies, this is a term generally used to describe a new technology. And this may also refer to the continuing development of an existing technology. The World Economic Forum's top 10 emerging technologies of 2020 include the following. 1, microneedles for painless injections and tests. 2, sun-powered chemicals. In other words, the sun is used to catalyze and form other chemicals. Virtual patients. And virtual patients means patients who can, for instance, we've been going through COVID, patients who can be used for testing viruses, for testing vaccinations, for testing medicine and the like. Number 4 was spatial computing, and spatial computing is normally applicable within the real estate sector, where you have, for instance, for lack of a better word, alert furniture. If you have, for instance, someone who is incapacitated or has a disability, when they are moving to a certain location, the furniture adjusts and gives them away. Or if someone leaves the house, the lights go off automatically. Or if a fridge is empty, it will go off instead of continuing to run. Some of this technology that we are talking about is not yet here, but for instance, I've been able to experience some of this technology in South Korea. Digital medicine has been very useful, especially in the COVID era, because robots or machines are able to actually provide medication. They are able to, using certain data that you're moving around with or data about you, they are able to prescribe, to diagnose you and things like that. Electric aviation is an attempt to use electricity to fly aircraft instead of fuel and things like that. And of course, this includes the design of the aircraft itself and attendant things. Number 7 is lower carbon cement. Number 8 is quantum sensing. Number 9 is green hydrogen. Number 10 is whole genome synthesis. Now, these are very utopia to us right now. So in addition to that, those were the emerging technologies as determined by the World Economic Forum study in 2020. But there are those that are within us that we normally call the 4th Industrial Revolution, things that we've been able to see either on YouTube, on the news, and things like that. These include autonomous vehicles, they include robotics, they include 3D printing, they include 5G, they include precision agriculture, they include digital marketing, automation and mobility, data and analytics, social networks, which young people really love, cryptocurrencies, blockchain, smart contracts, artificial intelligence, and many, many others. So I'm hoping that we now know the stage that has been set for us, because many of these things, whether they are here or not, they are coming to Uganda. They will be utilized by businesses. They will be utilized by individuals, including yourselves, if you're not already utilizing them. And when you utilize this technology, there are certain attendant legal issues that may arise. Now, what we know is that these emerging technologies largely utilize what we call big data. And big data is high volume, high velocity information assets that demand cost-effective, innovative forms of information processing that enable enhanced insight, decision-making, and process automation. One may ask, isn't big data a dream? But big data is not a dream because we all contribute to it. Even in this webinar, we are contributing to this big data because we have all our phones either connected or laptops. We are connected to the internet for us to be able to be here. If you're moving, you're listening as you're moving in the car. So all those things are collected by all this technology. And because of the voluminous nature of big data, they are also very useful for analysis and for innovation. For instance, there's a gentleman called Mar who gave a big data perspective, and he gave 25 facts about big data. And I would like us to go through that. He stated that every 2 days, we create information greater than the beginning of time to 2003. And these are old statistics, so you can imagine what is happening now with the advent of the pandemic and the fact that most of us have now gone digital. 90% of data in the world was created in the last 2 years. So that gives you the volume of data and the speed at which we are creating this data. By 2020, digital information will grow 3.2 zettabytes. And I'm sure this has gone up because by that time, we didn't know that COVID was going to happen and we'll all go digital. The total amount of data stored by industry doubles every 1.2 years. Every minute, 204 million emails are generated, 1.8 million likes are generated, 278,000 tweets are generated or tweeted. And of course, that has continued to grow. Google alone processes on average 40,000 search queries per second. 100 hours of video uploaded to YouTube every minute. And it will take you 15 years to watch every video uploaded in a day. Now, all the sources of this data are ourselves. When we are listening to music, reading books, our phone browsers, when we do conversation data and send emails, social media creates a lot of that. Phones, photos and images. We are obsessed with taking images. We want to post each and every activity that happens in our lives. When we do that, we create a lot of data, and this data is about us as individuals. It includes sensor data like GPS. When we move, most of this technology already can triangulate where we've gone, where we have been, how long we've been there, and many other things. Of course, this data is now utilized to be able to be innovative and provide some of the things we are talking about. When you look at, for instance, precision agriculture, for it to be successful, there must be soil tests, there must be crops to plant, there must be a study of weather patterns. There are so many things that they have to have in mind before developing this data. So while this data is very important and very useful, we also have to be cognizant of the fact that it can also be abused. Secondly, in many cases, it eliminates the human element. So there are certain things legally that we must be looking for, that we must address our minds to, and ensure that we not only protect ourselves as citizens, as human beings, but we also protect those entities that we are advising. Now, the IT legal and regulatory environment in Uganda has a number of laws that I'll briefly talk about. We have what we call the cyber laws, and these include the Electronic Transactions Act, the Electronic Signatures Act, the Computer Misuse Act, the Data Protection and Privacy Act, and many others. Of course, this also includes the Uganda Communications Act that regulates telecoms, because many of us, most of our gadgets for communication are our phones or our computers, but the bulk of us use our phones because of the ease of use and the fact that they are mobile. Under those laws, we have a number of regulations, which I will not go detailed into. Most of these regulations you can find on the NITA website. Beyond that, we also have government policies. Before laws are created, policies are done, strategies are put in place, once standards are developed and the like. So that forms part of the regulatory environment that regulates this technology. Now, I thought it was important for me to give a brief overview of many of these laws, since this is a learning session. We have the Electronic Transactions Act, which basically eliminates legal and operational barriers to e-transactions. It enhances public confidence in the use of e-communications and e-transactions, and it promotes the use of e-government services. What does this mean in real life? What this means is that previously, when we required physical documents, you can now submit an email, you can submit an electronic copy, you can be able to complete contracts online, you can complete a contract, or actually even sign a contract by email. There are so many other things. You can even sell goods online. If you've heard of Jumia, I'm sure you have. If you've heard of even mobile money to a certain extent, because you still have a contract, you deposit money, and you have that reasonable expectation that you'll be able to utilize this money, and you'll be able to utilize it to pay for your goods. Of course, what we need to know, sometimes we forget, is that even though these transactions are happening electronically, they still have to meet the fundamental requirements of the law. For instance, when you're concluding an electronic contract, there still has to be an offer, there must be an acceptance, there must be consideration, you must prove the intention to create a legal relationship, and there should be certainty of terms. So you have to make sure that even if you're transacting electronically, all these facets that you'd ideally look for in the physical realm must also be applied in the electronic environment. One of the things that we need to also be aware of is that under Part 4 of the Electronic Transactions Act, it attempts to protect consumers by providing certain minimum information that anyone who is doing an electronic transaction must provide. Some of the information that is required is the name of the business and its physical location, the consumer communication channels, a detailed description of the goods, information about the transaction, such as the full price, the taxes, how the good will be delivered to the consumer, and things like that. So it's very important that, yes, we may advocate for electronic transactions, but we must make sure that the legal, the foundational legal requirements are actually still provided for. However, we need to know that under this act, there are certain things that you cannot complete electronically. These include wills, they include powers of attorney, and they include documents that create or transfer an interest in property. So if you're going to transfer a piece of land, you'll still have to submit a physical document. You cannot do it electronically. You can do searches, you can submit applications, you can do all these other things, but when it comes to the actual transfer, you actually have to present the physical one. The reason I believe for this was because the government had to start with the transactional bits before moving to transfer of property because of fraud and things like that, and also give an opportunity for this sector to grow, or for people to actually understand how to operate within this with this technology before transfer of property is done. Now, for the overview of the Electronic Signatures Act, obviously, when you're dealing with electronic documents, in many cases, you have to sign. How will you confirm, for instance, that I've sold you a certain property? How will you confirm that the information you're receiving is from Stella and not from Iman? How will you confirm that the person who has sent you this money is Stella and not maybe Elizabeth? And we normally do that by providing our signatures or affixing our signatures on these transactions. When we do that, we are confirming that we agree with the terms set therein, that we are happy with the terms that have been set, and basically we flag off this transaction. Electronically, that is also possible, and government enacted the Electronic Signatures Act to facilitate the use of these electronic signatures, and it also specifically recognizes electronic signatures and provides that they have equal treatment with paper-based documentation and the others. Now, sometimes previously, now things are better. Previously, when I used to explain electronic signatures, people would have the view that this is some, something that they've not related with. But when you log into your Google account, you use a password. When you pay mobile money, you still use a PIN code. For many of you who have bank accounts, when you withdraw money from your ATM, you use a password. If you're like my bank, you have a two-factor authentication. If you're doing, let's say, online banking, yes, you'll enter the password. They will ask you a trick question whose answer you gave them, you provide that, you do the transaction. Before you complete it, the bank sends you a notification, a unique number that happens for each and every transaction you do. You enter that number into your online transaction and then complete that process. Now that whole elaborate process is your electronic signature. What is key for the law is that that electronic signature must identify you, and it must indicate your approval of the information contained in that message or that instruction that you're giving. So the law does not prescribe, let's say, that you must use passwords or you must use PINs or you must use two-factor authentication and the like. What it wants is that whatever system you put up, it must be able to identify me. It must be able to indicate my approval of the information or the instructions that I've given you. Some of the technology that we've been talking about in emerging technologies like blockchain also enables that assurance, because that system generates and stores data specific to you. And it is able in some cases or in many cases to indicate if someone has tampered with. So as we continue to use technology, we are getting better and better at avoiding fraud, at providing that assurance so that more people are able to adopt it. Lastly, under the cyber laws, I would like to talk about the Computer Misuse Act. Really, this is the penal law that is meant to provide for the safety and security of electronic transactions. I think in terms of social media, it's one of the probably the most used, because there's a lot of cyber harassment, cyber stalking, child sexual offenses, and indecent images of children and the like online. So you'll find that we've had a number of people that have been prosecuted under the Computer Misuse Act. But beyond that usage on social media, this law is very critical to deter fraudsters, to deter people like hackers. I don't know if you've heard of the compromise to the URA system about 10, 12 years ago, where a lot of money was lost because certain people tampered with the system and were able to, for instance, clear cars as duty paid, when in actual sense the tax had not been paid, and thus creating loss for government. So there are a number of offenses like unauthorized access, unauthorized use or interception of computer service, unauthorized obstruction of use of a computer, unauthorized access of information, unauthorized disclosure of information, and many others. Electronic fraud, child pornography, offensive communication. These probably are the most known by the citizens, but actually things like electronic fraud are very rampant in the country, and there is increased prosecution for those offenses. It is important for us to take interest in these offenses because previously we used to mainly think that it's only the IT people who would intercept computers or obstruct computers or disclose access codes. But we found that actually this can happen to anyone, because many of us are utilizing this technology, we are engaging with this technology, and we are able to do many things with this technology. So this applies to all of us as users and also as lawyers, because these are some of the cases you're going to have to deal with as you proceed in the profession. One of the laws, it's outside the cyber laws, but it is really related. It is the Data Protection and Privacy Act of 2019. Now, earlier when I described big data and how technology contributes to the production of the big data, I think one of the things I should have mentioned was that most of this data is personal data. When you look at, for instance, social media, those pictures, that's personal data because they can identify you. Your name is there, your friends are there, your home location is there, UCU is probably there, the hostel you stay at is there, because beyond just the picture, the technology or your phone or even sometimes cars, they are able actually to send messages to various networks. For instance, the telecom service provider, to be able to provide you a service, your phone must connect to a certain mast within that area where you are to be able to receive that service. That mast is also enabled by another system somewhere, which will take a record that, Stella passed here, Elizabeth passed here, maybe, you speak for a certain period of time. If you do shopping online, there's a lot of information that you leave. You leave your payment details, you leave your preferences. That is why you find, even when you Google something, you'll start getting a lot of adverts, digital adverts that are speaking to the same issue or to the same issue you are looking at. So the Data Protection and Privacy Act is a comprehensive law that is meant to provide for matters on data protection and privacy. It is intended to protect the privacy of the individual, that is myself and yourself, and to regulate the collection and processing of personal data. Now, the application of the law, it applies to all persons, institutions, public bodies collecting, processing, holding, or using personal data within Uganda, but it also includes other companies that are outside Uganda, but are collecting, processing, holding, or using Ugandan citizens' personal data. And when we talk about this law, the data we are talking about includes data in any filing system. It may be electronic, it may be physical. So for instance, for UCU, your application forms for entry into UCU. They have your names, they have your telephone numbers, they have your parents' details, they have your home location and the like. That is personal data. Whether it is in a file or it is somewhere in a system, that is still personal data, and this law applies to it. Now, there are a number of definitions which I will not go through. We have the data control, and this is the person who collects this data. We have the data subject. This is the individual, such as myself, from whom personal information has been requested, processed, or collected. Then we have the definition of personal data. I believe, given the descriptions I've been giving, we all have a general idea. This is information about a person from where that person can be identified. It could be your nationality, it could be your age, it could be your marital status, your education level, your occupation, an identification number such as your NIN, any other information. And that's why we say even location data, as long as it can be identified to you or it can identify you, it would still be part of this, covered by this law. If we consider anything under this law, as lawyers, we need to know 7 principles that are advocated for under this law. And these are international principles. So wherever you go within Africa, they will still be the same. When you go to the UK, you'll find the same. You go to Asia, these are the 7 basic principles of data protection and privacy. Number 1 is accountability. And accountability means taking record or being transparent in the way you deal with personal data. When that data comes to you, how do you deal with it? It could even be your law society now. You have a number of members. How do you register your members? If you're going to share their information, is there a record? Do you do an analysis before you share that information to make sure that the sharing will be lawful? You have to record all these processes. The processes must be lawful. In other words, you must collect this information or process it fairly and lawfully. Do you have a law that authorizes you to collect or process this data? Do you have a contract with this person from whom you're collecting this data and things like that? The third principle is minimality. Only collect what you're going to utilize. The fourth one is lawful retention. You only retain or keep that personal data for a certain period that is either authorized by law or by the need. Once the need no longer applies, you're required to destroy this data. But even when you destroy that data, you have to make sure that you dispose of it responsibly and it does not end up in the wrong hands. Quality, this is to ensure quality of information that is collected, processed, used, or held. Because as we know, if you have the wrong information about Elizabeth, it may impact either her movement to the next level or her graduation or things like that. So it's important that we have quality information. Transparency is very important. And this transparency means you must ensure transparency and participation of the data subject. In other words, do you have my consent before you collect this data? If you're a company, do I know how you're going to utilize my data? Do I know how long you're going to keep it? Is that information readily available? Or when I come to you, you read me all these requirements and then give me a document that has very, very tiny print, which you know I'm not going to be able to read. Now, transparency means that I have been provided with the information that I need to make a decision or to provide me with that knowledge so that I go away knowing, yes, my data has been collected, but this is how it's going to be utilized. And these are my rights. I can write and ask them how they have utilized this data, who they are going to share this data with, and the like. And then, of course, security. Security is very important. While manually it's easy because maybe you lock the door and things like that, electronically it's also important to apply security measures to ensure that once that data is with you, you do not lose that data or it doesn't end up in the wrong hands. Because we are all data subjects, myself and yourselves, I thought it was important for me to also talk about the data subjects' rights as provided in the law. One of them is the right to access personal information. So you can, yes, ask a company, how much information do you have from me? How did you collect this information? How have you utilized this information? You have a right to ask for this information and it should be provided for you, to you. You have a right to prevent processing of personal data that is likely to cause damage or distress to you. In many cases, you may find in situations, let's of genocide and things like that, there's certain information that you may not want to be disclosed. You can actually request that and prevent the processing of that personal data. You have a right to prevent processing of personal data for direct marketing. However, the law allows you to enter into a contract for pecuniary benefit. You have a right to correct inaccurate personal data, and of course, rights in relation to automated decision-making, because as we'll go along, we'll notice that some of the information that we provide, for instance, assuming that we have 11 million senior 6 leavers, it may be very difficult to go through that entire process of allocating them universities. You may actually use a computer or a computer system to be able to allocate students to different universities, having determined the criteria. But of course, the challenge that happens with technology, sometimes there's bias, sometimes there's unfairness. For instance, if you were to say anyone who is 5'6" in height should go to UCU, it means that even if someone really wanted to go to UCU and is 6 feet high, they will not be able to enter UCU. So it's important that when we are doing these systems, we make sure that they are transparent and that there's fairness, there's no discrimination. The law also provides for certain consequences where there's a breach, and I'll not go over that. We also have the NITA Act, which provides IT services to government. It regulates the IT profession and authenticates IT training institutions. It undertakes and commissions research in the field of ICT. It regulates and enforces standards in the IT field. It is the regulator for data protection and privacy matters and things like that. Now, in many cases, when we look at technology, and I explained this earlier, there's that view that, you know, there are no rules. You can do anything. One of my favorite quotes was given by a gentleman called Stephen Wright. And he says, the internet is like the Wild West. There are no rules. And I really disagree with that. And I would like to explain to you why. Now, when you look at electronic transactions, for instance, I explained earlier that the law of contract still applies, whether in contract formation, whether in how you present yourself to make sure that you do not misrepresent the facts. There are aspects of consumer protection. There's even jurisdiction issues, even if you're online. And that is why sometimes when someone wants to enforce a certain right, they are not able to, because yes, you received the service in Uganda, but the provider is in the US. There are issues to do with privacy and data protection. There's a lot of monitoring that goes on with these systems, especially on our mobile phones, in our cars. We now have smart televisions, we have smart fridges, all these things collect information about you. And this can become an issue because sometimes you may ask, where does this data go? How is it used? Who benefits from it? What rights do I have? And how is this data shared? All these are legal issues that you would have to contend with. There are a lot of intellectual property law issues. Copyright, when we share those, and I think I know I'm one of the culprits. These books, especially the self-help books, do we ask how the person who has sent you this book got it? Did they pay for it? Do they expect to pay for it? Because someone applied their energies to write this book and they should benefit from it. You should be able to go to an online store and buy it, or go to a restock and buy it. Music, films, I think many of us are culprits in this regard. When we copy certain intellectual discourse online, do we, in our dissertation papers, provide, that I picked this from this website and things like that? Under tort, we have a lot of defamation, libel, slander, because anything goes, especially because we are not able to identify in some cases who the person is, because people go and create fictitious, let's say, Facebook pages and are able to abuse others using cyberspace. We have a big problem with identification. If someone has defamed you or your parent or your client, who do you sue? You may see a Facebook page that has Stella Alibateese when in actual sense it is not me. How do you determine culpability? When you look at, for instance, WhatsApp messages and the forwards, you're actually not able to know where it originated from. And because of that, we've created a lot of, I think, a lot of negativity, because while it's very difficult for you to, say something to my face, it's easy to do it because you're hiding behind that curtain and I'm not able to see you. The extradition challenges, especially when it comes to cybercrime, you find that one of the biggest electronic frauds affected, I think, over maybe 10 banks across all continents, and the perpetrators were somewhere in the East. When they tried to extradite them, the challenge was that the offense that they had committed was not an offense within their countries of residence. So that can be a challenge. E-disclosure is very expensive. And of course, especially for the girl child, there's a lot of cyberbullying and cyber stalking for women. As lawyers, you'll have to deal with electronic evidence. And Justice Mutonyi defined electronic evidence to mean any information stored or transmitted in digital form, like compact discs. This is a very old case, 2014. In this case, that a party at a trial or proceeding may use. But this evidence comes in many, many forms. You have the active data, which are the emails, the phone calls and things like that, that would be easy to find. But we also have the hidden data. For every transaction that you do on a gadget, that transaction, trust me, will be recorded somewhere. Even when you delete it, there's still some residual data. All our phones replicate certain data, to be able to give you a better service, to provide backup and the like. So all this would be part of electronic evidence that as lawyers, you'll have to deal with. Now, this evidence comes in many forms: emails, social media platforms, mobile phone records, other activity data on telecommunication networks, computers, and the like. I hope I've been able to really talk about the many legal issues that are presented by emerging technologies. I would now like to talk about some of the lessons that I see for young lawyers. If I could have just a minute. Just a minute. What has happened to my, okay. So some of one of the biggest lessons I think that we learn, this is not only actually applicable to young lawyers, it also applies to all of us. Our biggest lesson is that technology is going nowhere. So you adapt or you phase out. Now, when I started working in 1996 is when I started working. By that time, I was with Hunter and Greg, and we had a pool of secretaries. We had our plain full scope. So if you had to do a legal opinion, you'd write it on that on a sheet of paper, and then be able to send it to the secretary. They would bring it back, you change and things like that. Over the years, when I moved on, I found a similar system in NSSF. And I remember we had a big backlog. One of the reasons we had been employed was there was a backlog over prosecution of defaulters and things like that. And you'd find that we had many cases in court, and you'd have to do the charge sheets and things like that. But you'd send you'd write, first of all, you have taken the trouble, you've written down the charge sheet and several of them. You send them for typing, it takes 3 days. They come back to you, you make corrections, it takes another 3 days. Meanwhile, you're young, you're energetic, you want, to do this work, and you're not able to do the work. What happened is that eventually we said, no, we need our own computers, we can type. We were a team of about three lawyers. We started typing our work. Guess what happened to the secretary? Unfortunately, she was left with no work because we were now doing the work ourselves. So let's adapt to this technology. Let's go beyond social media. There's more that we can do with technology. The second lesson for us is that technology is very dynamic. When I entered this sector in 2011, there were many things that were not here. Things like the two-factor authentication, things like blockchain, things like Bitcoins, things like smart contracts, all those were not there. But you can imagine in a space of 10 years, the landscape has changed so much. So we need to be dynamic. We need to know that these changes will come. What that means for us is that we must continue learning. We must continue seeking information. What smart contracts will do, they will automate contract development. They may not be able to do everything because there's a certain part that, a human, especially when you're talking about risks and things like that. But when you look at things like mortgages, when you look at things like transfers, when you look at things like sale agreements, they will be automated. And smart contracts do not involve any human being. They are actually electronically generated. They create certain algorithms. They can even be self-implementing. In other words, if I were to invest 100,000 shillings today and sign a smart contract with the Housing Finance Bank, once my investment is due or has expired, automatically that system should be able to send me money without any involvement of a human being. So that is coming, and we need to be prepared for it. Because of that dynamism, we must be versatile and innovative, because the only constant is change. It's important that we make good use of technology. We can use technology for learning. And yes, COVID was bad, but COVID has also given us great opportunities for learning, for business, for networks, because by bringing everything to the digital forums, we are now able to enjoy learnings from other people. These days, we are always on webinars, and the presenters will come all the way from either South Africa, from Uganda, from the US, at whatever time. We have degrees. These days, you don't have to go abroad to be able to obtain a degree. There's a lot of potential for business, and this business can even be done by young lawyers, as simple as buying and selling something. Let's use them to grow our networks. I don't know how many of us are on LinkedIn. I noticed that many of us prefer, the chatty type, Facebook, Snapchat, is it TikTok, and all that. They keep changing, but we need to be able to utilize them well, because networks are important for lawyers. I know there are a number of lawyers who are getting business because of what they post on LinkedIn, because of what they post on Twitter, because of the discourse they have on Facebook. Facebook, not so much. I think Facebook is very good for conversations and then business. But Instagram has also almost overtaken Facebook in terms of business development, in terms of business support, in terms of digital marketing and the like. So we need to make use of these networks that we can generate using technology. Employment is very critical. I have a niece who told me last week, actually, over the weekend. She grew up in the UK. She has a job in the UK. She has another one in the US, but she has decided to come and spend 6 months here because she can do this work electronically. So there's no reason why young lawyers, young people, all of us really cannot embrace this. You can actually have 2 jobs, or a main job and then, a side hustle. Because what especially COVID has done, it has also, in many cases, many of us used to talk about flexi working or working from home. It used to be that ideal thing in, very credible companies, but now it is inevitable, and it has shown employers that actually sometimes some staff are more productive when they work from home than when they work from the office. But for many of us, that is also a good opportunity, because you may actually work for a US company without you ever having to stay in the US and still be able to earn. You will not always be young, unfortunately, so don't waste time. Whatever you do, immerse yourself in it, embrace change and new ideas. The 4th industrial revolution is here, and it is here to stay. There are many things that we are already seeing. When we talk about chatbots, it's not utopia. It's not something that is happening in the US. It is something that is happening with our banks here. The other day, I was also chatting. I had a problem with my online transaction, and the WhatsApp number that I was given was actually a chatbot. It was, yes, able to respond, but of course, because it's a machine, it has certain limitations, but it was still able to provide me with information that I needed. You must put in the work. Being digital does not mean you don't apply yourself. If it is a legal opinion that you must support a solicitor in the UK to provide, you have to make sure that you put in your effort and that when you evaluate it, it is worth the money that you have requested for. When I had just started working, I used to work under Mr. Kagumire, who is a partner in Hunter and Gregg, or Katera and Kagumire. And I really value the mentorship that he gave me, because every time I would submit a legal opinion, he really liked detailed legal opinions. He always asked me, would you be happy to pay £1,000 for this opinion? And for me, that has always been my yardstick. Before I submit anything, before I deal with a client or submit work to a client or even to my bosses, I always evaluate it and ask myself, would I pay £1,000? Of course, then £1,000 was a lot of money, but what is your value? What value do you bring on board? Lastly, we must make sure that we create value for our clients, because this technology will take some of our jobs, but there are certain things that a human being must do. And what will be left are those things that create value for our clients. We must think out of the box and we must always provide solutions. Thank you very much.
Thank you so much, our dear guest. Your excuse us, I think the speaker from Kampala campus, who's the moderator, has got a technical issue, but I'm able to. Yes, Mane.
Thank you so much, Ms. Stella. Yes, I'm really tired.
But something. Thank you. Well, thank you so much for the lessons and everything that you've shared with us. With data protection and privacy. Yes, Iman, are you there? Well, I'm a data protection and privacy law activist, and I've loved how you've taken us through the overview.
Yes, Peter, I'm here. Hello?
Yes. In the background.
I have noise in the background. I'm so sorry. I was moving, but I wanted to put forward one question that has been asked to Ms. Stella. And this is the question.
Hello, Iman. I think we've lost you, but if you could find a comfortable place and get back to us, that will be very okay. Thank you. We are so sorry for the inconvenience, Madam Stella, and all our participants. I think she just has some technical issues, but she will join us soon. Yes, I was saying that I'm a data protection and privacy law activist, so I've loved how you've taken us through an overview of the data protection and privacy laws, specifically the Data Protection and Privacy Act of 2019, taking us through the different principles. Yes, it is very insightful. Looking in position that where we have fourth-year students here that have been pondering whether to do cyber law or not. Most likely you've given us an overview, and we are proud to say that yes, we can make a conclusive decision on whether to go for cyber law, intellectual property, because of the way you've hinted on them. Well, you can bring in your questions and our guest speaker will be in position to answer as Iman is able to join us. Yes, I have a question here from.
Okay.
Yes, madam, I have a question from someone called Matthew. And Matthew is asking that how are online businesses taxed and are those businesses regulated, especially the ones that are on Facebook or Instagram where people sell items like shoes or clothes? Yes, Madam Stella, you can respond to that.
Okay, thank you very much, Matthew, for that question. Taxation is one of the challenges in the digital realm. What is certain is that taxation normally follows residence. So if I'm posting goods and I'm resident in Uganda, I'm required to pay tax on that. But obviously the challenge we have is the challenge of follow-up and identification, as I indicated earlier. Because when I sell my goods, URA will not be able to follow me up to that point. But things are changing. With increased integration, they'll be able to actually question you where your income is coming from. And if you say I sell goods and things like that, then they will be able to tax you. What is true is that the providers, it's very difficult to regulate individuals, but people like Jumia are regulated, and NITA normally provides them, assesses them, and provides a certificate. We call it the certification process. So once they have that process, we make sure that the things that I talked about, the consumer protection aspects of the Electronic Transactions Act, are actually complied with. In that assessment, we also make sure that they are registered for tax. So for those that are companies and the like, it's much easier for them to pay tax. For the individuals, it's very difficult because of the issue of identification. But otherwise, when it comes to tax, wherever the person who is receiving the money, who is distributing the goods is resident, normally is where the tax would apply. Thank you.
Thank you so much, Madam Stella, for responding to that. Well, we shall go into our other next question. And someone, an anonymous attendee, is asking that, are there any continental or regional initiatives around data protection and privacy in Africa, or I think meant in Africa? Yeah, it's asking whether there are other continental or regional initiatives around data protection and privacy in Africa.
Yes, we have them. I'll start at the AU level. Under the AU, we have the Malabo Convention, which talks about cybersecurity and data protection, and all countries are encouraged to assent to that convention. Uganda is still going through the assessment process, but I'm sure soon they will be able to assent to that protocol. Secondly, within the AU, there's also a program for harmonization of data protection issues, because as I indicated earlier, or maybe not, technology transcends borders. So one of the ways to create a safer space within which we can all operate in is to make sure that we have similar laws. If you remember the example I gave of the biggest bank fraud that impacted several banks across the world, even Uganda actually was part of it. We had the US, we had Asia, we had Europe. One of the challenges of prosecuting the perpetrators was the fact that some of them were in countries that did not necessarily have laws providing electronic fraud as a crime. So the AU is trying to, under that harmonization framework, to harmonize all our laws. And this will also be based on that Malabo Convention that I've talked about. Beyond the AU, we also have, you know, I'm a 90s girl, so OAU hadn't yet gone out of my mind.
It's all right.
It's AU now. So beyond that, we have the African Network for Data Protection Commissioners, which Uganda has also joined. And that network has a number of data protection commissions in West Africa, from West Africa to South Africa. Within East Africa, we have Uganda and Kenya, because we are the ones who have passed these laws as of now. So that network is there. We interact regularly, and the effort is to, first of all, have harmony within our laws, to assist each other, enforce data protection and privacy laws, and also to work as a block when we are negotiating, especially with the big giants like Facebook and Google and the like. Thank you.
Thank you so much, Madam Stella. Once again, we are so happy to have you here and responding to those questions, especially questions to. Yes. Wow. Yes. Most especially question.
Hello.
Yes, Iman, we can hear you.
Yes, thank you so much. I would like to first of all apologize. My network had issues, so I think I wasn't able to connect. I've been trying to move around and find better network. I'm really so sorry. Ms. Stella, thank you so much. There's a question that someone sent to me, and it goes, what is your opinion or say about the legal system and the current emergency of digital networking?
Yes, Madam Stella, were you able to get that?
Sorry, I had forgotten to unmute.
It's okay, dear. Do you remember the question?
Yes, I can see it here. What is my opinion about the legal system and the current emergence of digital networking? What I can say is that the laws that have been able to elaborate were done in 2011. And as you know, they were done with a broad sense, really, to allow anything that is legal, that is tagged as an electronic transaction, to be able to proceed. So if within the definition of digital networking, it can be defined as an electronic transaction, it should be able to proceed. However, we are aware that we did an analysis about, I think it was maybe 2017 or 2018, we did a gap analysis to find out which laws are missing within our sector, and we have a cybersecurity law that is missing. So depending on what the technology is, if it is not provided for within our existing laws, then we shall provide for those in the new laws that come. So maybe what we can be certain about is that technology keeps changing. When I see what has been happening over the last 10 years, it is really unimaginable. When I talk about chargerless charging, I remember we were brainstorming on something within NITA, and we had a number of these tech guys around us. And all of us had wires connected to our switches because many of us use computers. And I remember commenting that it would be good at one point to charge your computer without having to tap into a socket or something like that. But now that is already happening. So these things keep changing. But what is critical is that whatever technology you evaluate, you must make sure that it is transparent. You must make sure that it is technology for good. And you must make sure that the purpose for which it serves is a legal purpose. I think that's what I can say about that.
Thank you so much, Madam Stella.
Thank you so much, Madam Stella. We also have another question from an anonymous attendee. And this question is, the DPPA is not very comprehensive on privacy and focuses more on data protection. In your view, as a regulator, is law intended to protect data? Is the law intended to protect no data-related privacy, such as press from the press? Thank you. Can I reread the question?
Okay, I'm able to see the question. In terms of privacy comes in many ways, and this law was done to support the IT sector mainly, although it also covers physical documents and the like. I don't agree that the law is not comprehensive on privacy, because when you go deeply into the principles, because privacy really is more about what can identify me, because the opposite of privacy is that it is within everyone's knowledge, that it is common and the like. The international exceptions that we know are when maybe I publish the information. For instance, if I go to Monitor newspaper and I give them an interview, I cannot then say that my privacy has been breached, because by their own nature, the press are supposed to publish this information. If you look at the law itself, there's no exception for the press. The press still has to comply with the privacy of other people. But internationally, there are certain things that are agreed. If they are following up, let's say, on a government fraud, then they are authorized to actually release this information. So it depends really on the circumstances. In terms of being comprehensive, all the data protection and privacy laws follow those principles. And I believe when you follow those principles, you'll be able to protect the privacy of an individual. Because when you're, for instance, explaining the implementation of the law, and that is what I do, we normally explain, you start with determining what data do I need? Do I need this data? How am I going to use this data? How long will I keep this data? All those questions are not related to data protection. They are actually related to privacy, because you have to determine that whatever you collect, you actually either have the power to collect by law, or you've received the consent of the data subject, or you have a contract between you that authorizes you to collect that data. Data protection actually comes after, because once you receive this information, then you have certain obligations towards that information. So I hope I've been able to clarify that.
Thank you so much, Ms. Stella. I think you've answered the question. Then we also have another question again from an anonymous attendee that says that DPPA gives a lot of leeway to government to collect data, especially under Section 7, subsection 2. Are there any plans by the Data Protection and Privacy Office at NITA to come up with guidelines for government around data collection, processing, and retention, even when done under other laws, like in the case of censuses by UBOS?
Okay, thank you very much. That is a very good question. But I think for the understanding of all of us, let me read what Section 7.2 or what Section 7 of the law reads. And this section is about the consent to collect or process personal data. Section 7.1 provides that subject subsection 2, a person shall not collect or process personal data without the prior consent of the data subject. Section 7.2 provides that personal data may be collected or processed. In other words, for all the personal data that we collect, ideally, we must have the prior consent of the data subject. However, there are exceptions under Section 7.2 where data can be collected. And this data does not only have to do with government. It can even be a company, it can be a hospital, it can be a clinic, it can really be anyone as long as they fall within these exceptions. And these exceptions are where the collection or processing is authorized or required by law, which means that, for instance, the law should provide, let me give an example of mobile money registration, or maybe that's not a good example. If I give an example of registering your mobile number from MTN or Airtel or UTL, the Regulation of Interception of Communications Act requires you to register before they give you a telephone line. So when they collect this information or process it, it is because they are required to collect it from you. So when you go to them, MTN will tell you, I'm required to collect this information because the RICA Act requires me to collect this information. So whether you consent or not, they would collect this information, and they can even collect it from someone else as long as the law authorizes them to do that. Now, Section 7.2b says where it is necessary for the proper performance of a public duty by a public body, and that's where government comes in. 2, for national security. 3, for the prevention, detection, investigation, prosecution, or punishment of an offense or breach of law. C, for the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering into a contract. D, for medical purposes, or E, for compliance with a legal obligation to which the data controller is subject. So these are exceptions, and I think when you get time and read through them, you'll see that they are valid. Because if you have a medical emergency, it's very unlikely that you'll be able to give consent. If you're part of a contract and you've already authorized me to collect certain information, let's say from NIRA, you'd be able to collect this information. However, to directly answer the question that has been asked, yes, there are a number of guidelines that we are going to be working on to be able to guide. Even when the law says that you can collect this information without necessarily getting the consent, even when you're government, you're supposed to still analyze, do I need this information? You still have to comply with the principles. How long will I collect this information? You still have to give information to those data subjects. You may not do it, for instance, individually, but it should appear on your website, how you're going to utilize that data. And yes, we intend to provide guidelines, and the guidelines will not only cover this, they will cover transfer of data. We are working on one on obligations of registered parties. There are a number of guidelines that we are going to do. And obviously, once they are out, I don't know whether you'll have finished your 4th year, but they will be published to enable us to get views from the public. Thank you.
Temoge, thank you so much, Miss Stella.
Iman, where are you?
I'm at home, so I was asking them to keep quiet.
It's okay.
Yes, we also have a question from Dominic, and
Yes.
he says, personally, as a law student in his final year, he would like a bit of insight on cyber law before he can take it as a course unit. What could be the advantages of taking it as a course unit?
That's a very good question. Dominic, first of all of us are going to be dealing with technology. Remember my lessons? That technology is going nowhere. So you either adapt or you phase out. Secondly, because everyone is going online, there are a number of opportunities for young lawyers. One of the biggest opportunities that is there is to work as data protection officers. If you've read, for instance, the data protection law, it provides that each and every person who collects or processes data must designate a data protection officer. Now, for those who are able, those are new jobs. For those entities that are not able, still, if you're the lawyer there, they may want a lawyer who is versatile enough to do the other work and also provide guidance on data protection issues. That is one. Secondly, I indicated there are a number of things, a number of challenges. We talked about tax in the digital realm. We talked about training. There are so many opportunities that you can get. But most importantly, it is important for you to understand how these technologies work and how the law interfaces with them. Because ultimately, whether it's government, whether it's businesses, we are all going online. And understanding how the law operates within technology would be very important for you. Personally, I think there are many opportunities, and if you take cyber laws, it gives you a certain edge over other people. Thank you.
Thank you once again, Ms. Stella, for that insightful reply. So right now, I think we are going to take on our last question. And this question comes from the speaker. And he says, right now in East Africa, we only have Uganda and Kenya. How can we effectively implement the DPPA when personal information is in the hands of countries that don't have data protection and privacy laws, most especially when it comes to the cross-border transfer of data?
Okay, thank you, Speaker, for that question. You know, we all dance to a different tune, a different roadmap, different timelines. Many of you are still young, but when you have children, they all don't grow at the same time. But it doesn't mean that you do not build a house to secure all your children. You may have one now or 4 like myself, but you provide for that space. So we shouldn't be disheartened. All the other countries actually are in the process. Maybe what I didn't mention, for instance, within East Africa, we have a forum under the EAC. And under that EAC, the ministers approved the EAC Cyber Harmonization Framework. Under that framework, all these laws were supposed to be developed, including the data protection law. Now, we've had a different journey for each country. Uganda has been a bit faster, but you find, I think Tanzania was the last, but we may move at different levels or maybe speeds, but we are all going to the same destination. And what is true is that within Africa, the issue of data protection is really, really growing. So it even gives an opportunity for some of us who will have practiced before to be able to provide support and work with other countries. Thank you.
Okay, thank you so much, Ms. Stella. According to the agenda, I think we have really managed our time very well because we've been able to get the insightful discussion from you. We have been able to ask some questions and of course receive the very good answers from the right person. So right now we are going to make a few announcements and then we shall have the closing prayer and remarks from the Finance Secretary of Mukono. However, personally, I would like to thank you, Ms. Stella, for this very insightful discussion. I'm a third year, but I already see myself opting for cyber law as a course unit. And basically the fact that it covers technology, which is something that is part of our life, whether social media or everything else. So this really matters to everyone, regardless of whether you're a law student or not, because on this session, we do have people that are not law students, but they come on board and attend to pick something. And this has been a very insightful discussion. And I would like to personally thank you so much for opening our eyes that there is more to technology than the social media that we have. And I also would like to confess that I didn't know LinkedIn existed until I was doing some research on you, that I learned about that and joined. The announcements that we have, there is a discussion that was organized by the Speaker of Mukono that is going to take place tomorrow. And then also the Law Society end of month fellowship, where the preacher is going to be our very first guest speaker, Dr. Ruhweza Daniel. So we ask everyone on the platform to please join us in the two events that are going to happen. The fourth year students, there's an opportunity that has been presented to you. Please endeavor to participate and attend. And to all the law students and everyone that is on board, you're all welcome for the UCU end of fellowship. So we are going to get Ms. Stella's email address for those that still have questions that we can engage her in. You can send her an email. We shall share it on the platforms that we've been sharing the communications so that we can keep in touch with her. Thank you so much, Ms. Stella. We really appreciate the time you have spared to talk to us and the insightful discussion. So I would like to invite Norman, Mr. Ochora Norman, the Finance Secretary, to say something to us and also conclude the session for us. Norman, are you there?
Yes, yes, I'm here. Thank you so much. Iman. Thank you so much, Madam Stella. Though I took a data protection, managed to attend. It was very insightful. Bitcoin, and I'm glad you meet. And cyber law. For me, I wanted to do both because to know these details about everything, you need to know how both work. Anyway, back to the point. Thank you so much, everyone, for attending. We encourage you to attend again come next month. I'll give the prayer after my last communication. I would like to thank everybody for contributing to the 1K campaign. Maybe Madam Stella may be the only one who has not got insight, and maybe anybody else on the call. This is a campaign to raise tuition for our friends who are yet to graduate in October. There are few who are running short of the required amount. So we thank everybody for contributing their 1K, 1,000 Ugandan shillings. And we thank those who have contributed more than 1,000 shillings. And we thank those who have continuously contributed 1,000 shillings every day. Out of the 5 million shillings that we need, we have been able to raise from yesterday 891,000 shillings. This is a big thank you to you all. Thank you to God for having brought us this far, and thank you for everyone for their cooperation. We encourage you all to keep in giving. I'll be blessed. Surely you will all be blessed. Thank you so much. Let me say the last prayer. Not the last prayer, that sounds so wrong. Let me say the closing prayer. Thank you. Let's humble ourselves and we pray. Dear Heavenly Father, we thank you for the gift of dear life. We thank you for having brought us together today to talk about the gift that you give, protection and everything. We thank everybody who has attended. We thank you for the gift of knowledge that you've blessed Madam Stella to share with us. May you bless her in all our endeavors. May you bless our panelists, Iman. May you bless everybody else who has been able to join us today. May you bless all the endeavors that we shall go and do from now on set. May you bless us, and may you give us light in everything that we do. Lord, we put the souls of the faithful departed into your hands. Eternal rest grant to them, O Lord, and let perpetual light shine upon them. May they rest in peace. Amen. We ask all this through Christ our Lord. Amen.
Amen.
Thank you so much.
Amen, brother.
Thank you so
much,
all.
everyone.
I'll make my contribution to the 1K campaign through the president.
Thank you so much, Miss Stella.
Okay, then. Bye-bye.
Bye-bye. Thank you, everyone.
You're welcome. Thank you too.
Thank you. Thank you so much.